Welcome to the 18th episode of Certum Group's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar from the top law firms and legal institutions from all across the country. On this program, we discuss the latest trends, risk mitigation, and settlement strategies that are currently happening across the entire spectrum of commercial litigation, including class action litigation, which is going to be a special focus of our program here today. I'm your host, Kevin Skrzysowski, with the legal consulting firm Certum Group, where we work to design bespoke litigation risk transfer solutions for our client and our counsel. And today, I'm very pleased to be joined by Jack Clabby, a shareholder at the law firm of Carlton Fields, where Jack leads the firm's securities litigation and enforcement practice and is also co-director of the firm's annual Carlton Fields class action survey. Jack, it's a pleasure to have you on my program today.
Hey, Kevin, it's great to be here. Thanks so much for having me. And you talk about risk transfer. I mean, that's a lot that comes up when we talk to the participants in the survey. Class actions, like any other complex litigation, it's about how much risk folks are willing to take on and ways they mitigate it. So this is a great opportunity to talk about exactly that with you, who knows quite a little bit about that.
Yeah, and I think our interests are very aligned in that. We dedicate a large portion of our business to trying to work with clients to design optimal settlements and ensure them to help them transfer those unknown risks and really sort of mitigate, cap, and transfer any downside risks they could have in class action litigation, which is why we're here today. So today we're going to take a deep dive into the results of the 12th annual edition of the Carlton Fields Class Action Survey. This is a really great publication that your firm produces. It is widely discussed across the class action industry with both plaintiffs and defense counsel. And really, it's fantastic. It provides such a wonderful overview of all the important issues and the practices related to class action matters, including the historical trends, and perhaps even most importantly, emerging issues. So, Jack, could we start by having you tell us about the demographics of the respondents to the survey? Who do you elicit to contribute in this publication?
So it is the biggest companies in the U.S. So we speak to either general counsel or chief legal officers or their direct reports who are responsible for litigation. And each year it's about 400. So this year it was about 410 of these chief legal officers who we spoke to. And it's a wide-ranging survey about what they're facing now, what they anticipate facing in the future, and then how they go about managing these. But I think the average annual revenue of the companies that responded to this survey was about $23 billion. And so these are big companies. The reason we do it this way, there's a couple of them. But first, larger companies like this tend to face more than one class action. And so that helps us benchmark. You're not talking to a company that might get one class action every other year, but companies that might have multiple open and have gone through the process of developing management strategies. Additionally, folks like that also tend to have in-house teams, some who might specialize in class actions and some who do other things. That also helps us when we're looking at management practices to think about separation of skill sets among that team and gives us a little bit of a better sense of what works and what doesn't. But that's really what it is. It's the biggest of the big because we're trying to find those companies that face class actions and have some story to tell about how they manage it.
That makes a lot of sense that you're really looking for like critical mass of people with the experience, with the highest volume. And this is probably an obvious question, but I assume it's industry agnostic.
Yeah, so that's another part of it too. We've thought over the years about doing industry deep dives, but we like the anonymity that this allows to the in-house counsel. If you start to dive into one industry alone, it makes it harder for us to protect the folks who are responding. That candor that the industry agnosticism allows, I think, is one of the real powerful draws to the survey results itself.
Definitely. I think also given the breadth of the docket of class action litigation that's out there, you could be a company in almost any industry and be on the receiving end of anything from securities to labor and employment to consumer to statutory. So I think your methodology makes a lot of really good sense. So let's dive in. And we'll start with probably the question that's on everybody's mind, spending and costs. Over the last several years, what trends have you seen with corporate legal spending, defense of class actions?
I mean, it's big enough at this point that it really is an industry, right? Class action defense is an industry. And I think what we're reporting this year is $3.64 billion. So more than $3.5 billion being spent on the defense of class actions. That's both fees and costs for the defense. Does not include the actual settlement value itself. So that tells us a couple of things. From the survey this year, the claims year over year are getting bigger and more companies within the cohort that we examine are facing them. right? So you're getting an expanding number of total class actions, and you're seeing each of those class actions, again, on average, getting bigger. That growth is pretty substantial. I mean, even 10 years ago, it was just a little bit over 2 billion. So it goes from 2 billion to over 3.5 billion in the 10 years that we're looking at. So it really is a growing and somewhat extraordinary piece of it. Now, you might see that's an aggregate number, and we're going to talk a little bit about what types of class actions are growing versus the other. We do break it down in the survey by particular types of lawsuits that tend to be taking up a larger share of that class action spend, but it's significant. And it really is those two drivers. It's the claims getting bigger and more companies facing them.
So what's the forecast for 2023? Do you think we'll hit 4 billion or come close to 4 billion in spending on fees and expenses?
Yeah, I think we're going to keep seeing it going up. I don't think we're quite at the 4 billion mark yet. I mean, these things are Rubicons, right? That the takeaway from it, sometimes these numbers get cited in general ways in briefing from our survey. But the real idea is it's expensive. And so if there are policymakers who are using the findings of the survey, this is a number that they always point to say, this is just friction, right? This isn't even money being spent on settlements. This is just the idea of litigating and defending these claims. And you see throughout the survey also sort of a frustration from these general counsel that comes through with the data. They know these are sophisticated in-house counsel, sophisticated lawyers. And so they know a reasonable claim that they're going to sort of investigate and then resolve. They also know one that's frivolous. And this year, I think for the first time we saw, in terms of what in-house counsel saw as one of the larger risks, 6 out of 10 of our survey respondents said it was baseless claims. And so, look, the consumer bar, the plaintiff's bar is going to see that differently. I think we're not taking a side either way, but some relatively large portion of this is considered by anonymous in-house counsel who know what they're doing as being baseless. And so a lot of these costs are costs that, if the system were to work a little better and maybe clear some of these out quicker, would be costs that could never need to be borne.
Yeah. I think just looking at that, the data that costs spending on fees and expenses was at 2 billion 10 years ago, and now it's a little bit under 4. This year, 3.6 is just a testament to the plaintiff's bar in finding new and creative ways to sue American businesses. But that's my side comment. But anyway, so we're definitely seeing massive growth over the past 10 years. So let's talk about where that's coming from. What are the most significant growth areas? And I like your opinion as to what you think are the emerging areas in 2023 or what we're already seeing so far in Q1 of 2020.
That's right. So we present these sort of figures in two different ways in the survey. We talk about the snapshot of what's happening now, what's on the individual dockets, and then what do these same decision makers think is coming over the next 12 months. And so for what they report in 2022 for the year completed is that by far, labor and employment is the largest type of collective action that they're facing. And that's almost 1/3 on average of these dockets for these 410 companies in our survey are labor and employment claims. The next closest at about 22% is consumer fraud. Then we have other categories, including insurance and technical statutory violations. We saw some contraction. So products liability, which is always hovering below 10, did contract this year to only about 3% of the docket. So that had a little bit of a contraction, as did antitrust. But really, this was the year of labor and employment and consumer fraud. In terms of what's expected to sort of be the next wave of new filings, data privacy and cybersecurity has been at the forefront for the last couple of years. And I think we're looking now at about 25% thought that was going to be the next wave. And then consumer fraud, again, there's a lot of worry out there, particularly as to the consumers and employees all having access to easy communication devices on social media that can both cause risk and also amplify a harm that takes place offline through drawing attention to it through social media. So really, this was the year of labor and employment and consumer fraud. We anticipate next year from the survey respondents, again, it's going to be an uptick in data privacy as well as more consumer fraud is coming. I think they're not predicting labor and employment next year because that wave is already here. We're seeing it now, so it's not coming. They're sort of ready for it, and they're in the thick of it right now, Kevin.
Labor and employment's been high for a couple of years. I mean, why has labor and employment been so high in recent years? Is it tied to perhaps COVID and working from home and then like hybrid workplaces going back in? Is it more disgruntled employees and they're more aggressive in going after their employers? Like, what's the reason for that?
So our survey respondents gave us some good insight onto this from the sort of anecdotal portion of the survey. And then I'll pivot and I'll give my 2 cents on what I think this means for the industry. But the survey respondents told us that they saw an uptick in activity from regulatory agencies. And when that uptick happens, there can be either follow-on actions in the private bar or, the same press releases from the government that are read by the plaintiff's bar are read by employees. So they might say, hey, I didn't even know that was a problem. If they see like a headline from either a federal or state agency talking about an enforcement action, they say, well, that's happening in my company too. They don't necessarily go and report it to the state. They might go and find themselves a plaintiff's lawyer. So it's the changes in federal administration, changes in state administration have a cascading impact, particularly in labor and employment. So that was what the survey respondents said. Additionally, we're seeing in practice at Carlton Fields is you had some innovative plaintiffs' attorneys. Yeah, I think you mentioned this a moment ago, Kevin. Like there is innovation that's taking place, some of which sticks around when there's some good court opinions, some of which falls by the wayside if the defense bar gets the better hand of it. But once that innovation gels, you then see other plaintiffs' attorneys copying it or using the precedent as ways to generate new business. And so I think some of that was what was happening over the last year with employee misclassification cases, wage and hour cases, with a particular focus on work from home environments, where now you have this data of when is an employee logged in and not logged in? When are they working and not logged in? So there's like sort of a data before if an employee is working in a building, you have less precise data on when they're on and when they're off. But the work from home did allow for that same monitoring, which itself has formed some claims, Kevin, can also be used as evidence to the extent there's some back and forth that needs to happen in discovery about when this person was working and when they weren't.
No, thank you for that explanation. That all makes sense. I know I just read some articles recently about companies investing in that tracking software to look at keystrokes and when employees are on and when they're off. So definitely, I can see there could be some disgruntled employees that lead the litigation. And then I don't operate so much in the labor and employment world, but I do operate mostly in the consumer fraud world. And I personally know that increase in consumer fraud claims, a lot of it is coming in from like false advertising and mislabeling claims. There's like a huge push against all consumer packaged goods manufacturers, consumer brand association type manufacturers, against anything they say on their label, healthy, non-GMO, sugar-free. I know a head of litigation from a major food and beverage company joked to me at a conference a little while ago that eventually they're going to go back to like a white package with black label because of milk, because we can't say anything. But it's all over social media. And I think social media that you mentioned a moment ago is a driving force, not just in filing of lawsuits, but also in the claims rates in publication notice campaigns as well, at least those that settle with that type of notice structure. We're seeing is the amount of fraud that is coming in from those programs, from bots and from feeder websites. It's at an absolute unprecedented low, and it's making financial predictability almost impossible. So let's talk about a number of class action matters. And you mentioned that most of the respondents to your survey are large organizations and they have multiple. But what's trending in terms of the average number that a company is actually defending, and how many of those are like high risk or about the company?
Yeah. So this is an interesting finding. After the last 2 years, we reported from 2019 to 2020 and from 2020 to 2021, the total number went down. So each of these large companies was facing less the year we reported on than the prior year. So that reversed in this year's survey results. So it went from last year's number of 8.9 up to 9.6. So that's a pretty significant jump in the history of the survey, that it looks like this 2-year trend is over and filings are back up again. And I think during COVID, there was some clearing out of older cases and something of a reluctance to file. There were a handful of pending Supreme Court cases and circuit cases that would help determine that. But I think that's over. I think we're back to seeing active dockets here. Again, a large chunk of that is going to be labor and employment and the kind of consumer labeling and consumer fraud cases you just mentioned, Kevin. But these are real cases that are going to need to be faced. So the trend is over. And I think the uptick is here, and it's predicted to go up again about probably half a case on average into 2023 by our survey respondents. Again, that's not our prediction. That's the prediction from the 410 in-house lawyers who did this. Now, in terms of the risk to these companies, we report in the survey that bet the company really isn't a thing, right? It was even a couple of years ago, you would see 1 out of 5 or so class actions, or 1 out of 6 class actions being described as bet the company. Okay. And when you think about that, the resources you devote to that are it's limitless because the whole company is at risk. Over the last 2 years, that number has gone down substantially. And this year, bet the company was 2%. Think about that for a second, right? So for those of us who sort of look at this, it's in an odd way, it is more interesting to talk to clients and in-house lawyers about not bet the company cases. Because when you say bet the company, it's like, oh, just throw everything at it. Don't worry about it. But when you're talking about a complex or a high risk case, they're making those trade-offs, those cost benefit analysis. Like, are we going to boil the ocean? Are we going to depose everyone who might have touched a potential class rep? Or are we going to make some strategic decisions about deployment of resources? There's a lot more you can do to manage and control the cost of a complex or a lower exposure class action than you can at the high end. So to use a baseball metaphor, in the last game of the World Series, you're not worried about pitcher usage, right? You just throw everybody you got out on the mound and win the game. But now we're talking about essentially mid-season baseball, which is you're looking at resource management. And so I think that also gets to this industry complex of if a lot of the class actions that are on these dockets are repeat class actions, where you have good data on what a settlement could look like. You have good data on take rates for claims made settlements, right? Or if you have good data on what it should cost against this kind of a plaintiff's attorney or this plaintiff's attorney and this type of issue, you can do a lot with that data, right? To predict outcomes, to control risk, and to keep costs in a way that when the GC is reporting up to the board or to the CFO, that GC can have some certainty.
So we're seeing definitely an increase in the average number of cases that each company is defending. And there might not be as many bet the company matters, but there are definitely high risk matters. Yet your survey indicated that the number of in-house attorneys dedicated to class action defense continues to decrease.
Yeah.
And the percentage of defense costs covered by insurers also decreased by double digits, which I think all signs are indicative that in-house legal departments are being forced to do a lot more with a lot less. So with that, then let's turn our attention to how companies are actually approaching class actions. And let's just begin by going right to settlements, maybe then reverse engineering from there. What did we see in terms of the number of individual settlements in 22 and the number of class-wide settlements? And can you explain that correlation or lack thereof?
For sure. We look at it in those two lenses. We look at it as of the docket that you had in 2022, what percentage settled, right? And then when you look at that settlement bucket, how many were individual versus on a class-wide basis? And really 2 years ago, 2021 was a watershed year where there were, I think, something like 73% settlements, which is just extraordinary, right? And again, these are big companies largely clearing out a lot of the COVID stalled litigation. So you really saw almost 2 years of settlements happening in 1 year in 2021. Things didn't just go back to the mean, though, in 2022. They actually shrunk further than that. So the class action settlements were less than half, which is sort of for the first time in, I think, at least the 5 years that we were looking at this particular issue. So it was 47% in 2022. That's a low settlement rate for these cases. And within that, though, we also saw historically high numbers for individual settlements. So we look at this and we say, there weren't a lot of settlements. And then within the settlement population, you saw a lot of individual settlements. And where do we think this came from? I think this is that thread of the frustration we talked about a moment ago from the in-house lawyers, where, if you think about an individual settlement, you're really talking about a case that both sides assessed as not particularly strong. Or maybe you had an injured class rep, but you didn't have that injury spread out evenly throughout the rest of the potential class. And so an individual settlement does make sense. On the insurance side, we saw, like last year, relatively low numbers, or at least in 2021, relatively low numbers for the percentage of defense costs covered by litigation. And then within that, okay, if you have some coverage, what percentage of the cost is being covered? So again, it's two layers. Is there coverage? And then if there is coverage, what's the hit going to be and how much is the insurance going to help you? And we saw kind of a little bit of a reversal in 2022 where actually the number went up pretty dramatically in terms of, are you getting coverage for these class actions? But then the coverage itself was paying for a lower percentage. So that could mean a couple of things. That could mean higher self-insured retentions or deductibles for these kinds of cases. It could mean some portion of a potential claim is covered and some isn't. But I like to think that there were brokers who went out, right, and probably saw the same things we were seeing. And we talked to the brokers. They're partners with us in some of these, as I know they can be for you as well, Kevin. But the brokers are smart about it. And they have these conversations with the big companies and they say, look, what's better for you, right? Having some percentage of the cost covered, or when the coverage happens, having it all covered. So these are the kind of trade-offs, again, that can happen in these larger cases. And I think some of the explanation for the insurance this year could be that it was a lot of labor and employment draw. And the way that insurance can sometimes work is that there can be higher SIRs depending on the type of claim that's there.
And I think the numbers with the increase in individual settlements and the decrease in class-wide settlements just goes back to your previous comments that there was a larger number of cases that were filed without merit, but then the ones that are filed and are with merit are very high risk. So the correlation is just simply logical. So in terms of those actual class-wide settlements, the survey noted that almost 3/4 of companies with class action settlements used a claims-made model in 2022, which points to the continued effectiveness of that form of settlement. Can you talk to me about what you meant by claims-made continuing to be an effective form of settlement? And is that saying it's more effective than perhaps the common fund form?
Yeah, so there's always an interest, and you can describe both the claims-made and the common fund as having, in the right case, it can make a lot of sense for both plaintiff side and for defense side, right? So it's not a judgment necessarily on either one of those forms. You think about in a consumer fraud case, a claims made can make a lot of sense, but in an antitrust case, maybe a common fund makes a lot of sense, right? So it depends on where you're going. But we've asked this question, particularly, we ask about a bunch of different features of settlement terms because, we always hear and we see in our own practices the ebb and flow of certain terms. And I think a couple of years ago, there was this idea that a claims-made model was stickier or harder to get through and get approved, at least in some federal courts in the country, that they were skeptical of what looked like a large number, and then a small number would actually be provided to benefit the members of the class who might have a damage. But our survey results over the last, let's say, 3 years have not borne this out, right? There has not been this report from the survey respondents that they've had trouble getting claims-made settlements approved, and that it remains a tool that's viable and that it's going to get approval, particularly in state court, right? I mean, there's almost been no real pushback in state court, but even in federal courts that have had some skepticism, we weren't seeing either in the data or in our anecdotal conversations, the idea that it was somehow of the two forms going to be your chance of approval was somehow lower.
Yeah. And of course, we always advocate doing a claims-made settlement. We're able to get them through on behalf of our clients in jurisdictions across the country all day, every day. We just think that's a great sort of an egalitarian form of settlement. Everybody has a chance to opt in. You get the exact same benefit structure. Unlike with the common fund, if only a few people come forward, there's this waterfall distribution to them. But if too many people come through, there's a de minimis payout that actually jeopardize getting approval from the court. So I would be curious to know how many of your respondents that did a claims-made settlement consider wrapping that settlement with a class action settlement insurance policy that we offer. And we try to always wrap claims-made with a class action settlement insurance policy to mitigate cap and transfer that downside risk and give the businesses who are settling cost certainty and help them exit the litigation very efficiently and cost effectively. But maybe that's a question for next year.
Kevin, I'll say this too, is that as good as the in-house lawyers are at managing their class action spend in terms of defense costs and expert costs, they don't have the touches on the ball in terms of what a take rate's going to be, right? I mean, it's so challenging. And these are the same folks who are looking at social media as the source of a lot of their risk for consumer fraud, products fraud, allegations, and labor and employment. And so I think they see the ability to get help from a product, right? From a risk mitigation product as taking away that thing where, look, they know what they're good at, and they're good at knowing liability for their company and what their risks are. They're not good at saying, okay, what's the take rate going to be for this versus my overall spend? And I think that's where the product that you're talking about really helps them. They're not the experts in that. They need to go talk to someone who is, or find a way to shift that so they can sort of stop with it.
That's right. And predictability is almost impossible these days. There are so many levers that drive risk up and down. And then your comment, as I mentioned previously as well, just the fraud that's out there. And with just the proliferation of get free money, file here, no proof needed. It's on TikTok and teenagers are promoting it through Snapchat. There's their own Facebook pages. It's just, it really is impossible. So now, do you think that the sort of I would say the dominance of the use of claims-made settlements then also had a direct impact on how many settlements used a charitable contribution? Because I saw that contributions plummeted last year.
Yeah, in 2021, I think about more than 40% of our respondents have been involved in a settlement with a charitable side to it. And that went down to 23% this year. So almost cutting that directly in half. There's a few causes to that. One is in the data itself, largely, to be fair, because last year there were so many settlements that in 2022, because that number went down, if there's less settlements, there's less chances to use that sort of feature. But I think the two other factors is, if claims made is going to dominate, you're going to see less of dealing with a residual that needs to get set to a particular university picked by a particular litigant or the judge, right? And also, I think you're seeing there were a lot of headlines in the legal press about some of the challenges of these charitable contributions as a feature. But even then, I mean, we were pretty surprised that still it remains 1 in 5 seeing this. I think there's still state courts that sort of allow it where it's almost like cultural, as weird as that sounds. But that's our only explanation. And that's speculation, to be fair. But 1 in 5 have been involved with the settlement still. But I think we're going to see that number go down in the next year or two.
Yeah, very. And I think one other reason is that I think some courts are also increasingly frowning upon the use of a charitable contribution, right? Cypre distribution for an organization that has no direct relationship to the lawsuit at all whatsoever.
Right. That's exactly right. Like there are plenty of charities that, there enough money moves around in these that charities can be taken care of. And look, I'm not saying there's not the right case for it, but I think the litigants and the judges in particular are pushing back a little bit on every case being a case for it.
Exactly. Jeff, let's move on and let's look at actual class action defense strategies. So what defense strategies were reported to be the most effective last year? And do you have any data on how effective motions to dismiss and motions for summary judgment were?
Yeah. So what we do is we ask this question to try to measure what are the popular ones, right? We kind of want to know what's the awareness of each of these. And then if they're aware of them, is it working or is it not? And commonality and predominance sort of stays at the top. Right. I mean, these are class stage defenses where you're looking at certification stage defenses. Lack of actual injury had a pretty big bump as well. And I think that's good to see. I think because that leads us to believe there's more of a judicial recognition for that at the class cert stage. The surprising one. So for the first time this year, we asked about motions for summary judgment. We call them early motions for summary judgment. So typically it's motion to dismiss, class cert, and then the last stage before a trial is summary judgment. And a lot of cases never even get to summary judgment that proceed in that path because there's either a win for the defense, a win for the plaintiffs, and a settlement.
Certs deny, but you saw a flip-flop last year. I was surprised to see this.
This is a huge number. And I think my firm appeared in something like 85 class actions around the country last year. We have a lot of good lawyers here who do a lot of this work. Every one of them was shocked by this, that 64% saw early motions for summary judgment as an effective technique. And I think that leads to this, again, it comes back to this third time to this conclusion that think about the case that early summary judgment motion like this is effective in. It would be a case where a plaintiff has artfully pleaded in such a way that they can get past a motion to dismiss. But as soon as the smallest amount of facts get out there, let me tell you really what happened, right?
Sure.
They're going to win. So that's the sort of case. So I think if early motions for summary judgment are effective, it's really going back to this idea that some of these cases are just never should have been brought in the first place and can gum up the system with artfully pleaded complaints that evade dismissal on the initial briefing. But as soon as a little bit of evidence comes out, the putatively plaintiff loses and gets out. So I think labor and employment is one of those where you see that. Consumer fraud can be another one. If they bring a consumer fraud and you find out early in discovery that the person never even bought or used the product, early motion for summary judgment, right? You don't necessarily need to wait for class cert to do that. File a 4-page summary judgment briefing and get the case out of there.
Yeah, just a brief motion. I think we're going to continue to see more of that as well. So Jack, we're almost out of time, but I did have one more question for you. I just wanted to get your thoughts on the results from the survey on mandatory arbitration provisions, class action waivers, and the use of AFAs. Are they trending up, trending down, staying the same? What did you say?
Yeah, so I think these are two areas where I think there's a lost opportunity. And so, we don't make a lot of prophylactic recommendations in this. We're really just reporting on the data and helping analyze what in-house counsel are saying and translating that and getting it out to the world. But for these two issues, I think we saw some misconceptions, right? So about half of the companies are using mandatory arbitration provisions that preclude class arbitrations, right? They can be really robust and those can be powerful. And there's been some high profile examples where it's saved and stopped class actions in their tracks, right? But some of the survey respondents simply said, we don't deploy those class arbitration waivers. Similarly, we don't deploy class action waivers because we're concerned in our jurisdiction about some adverse precedent. I would commend those companies to go back and look again at that because it's not the sort of thing, they can be so powerful that it's not the sort of thing that you'd want to speculate or rely on an article they read. That's something that's worth really drilling down on. And I think it's a missed opportunity. I mean, really only 43% of the companies are using class action waivers in one form or another. I think that's a real missed opportunity for defense counsel to help their clients and for companies to do it. And I think AFAs is the same thing. I mean, that number, the use of AFAs right now is at about 41% for class action. That, I think, for the sort of repetitive class actions that we're talking about, consumer fraud class actions, products class actions, and labor and employment, there is good data on what works and what doesn't. There is good data on each of these plaintiffs' attorneys who's filing these sorts of actions. And our survey found that in-house counsel is really using a tight group of outside lawyers for each of these cases. So those are the ingredients with which you can cook an effective alternative fee arrangement. So the hope is that folks will see this and will think creatively, at least in these repetitious class actions, do we have enough data to put together a good AFA and really help control costs? Because Kevin, as you know from your practice, right, predictability can often be randomly finding yourself with a smaller number than you wanted. You want to be able to plan, and AFAs at least provide that.
Predictability and cost certainty is tantamount to the business operations leadership within every single organization. It's what drives most of their decision making. That goes to the core of the business. If you have cost certainty and predictability, you can run the business, you can plan budgets, expenditures, and forecasts.
Absolutely.
That's it. So, well, Jack, and that was very valuable guidance and insight. I really want to thank you for your time here today. It was a pleasure having you as my guest. I want to thank you for all of your valuable insights that you shared with the audience and all of the insights that we gleaned from the 12th annual Carlton Fields Class Action Survey. Now, if anyone would like to contact you to discuss any of these topics that we covered here today, what would be the best way to reach you?
Thank you, Kevin. And thanks to the listeners. You can find me on carltonfields.com. My name is Jack Clabby, jclabby@carltonfields.com. And for more information on the Carlton Fields Class Action Survey and to get a copy, just visit carltonfields.com and it's just a few clicks away. So Kevin, thank you so much for having me on today.
Thank you so much for that, Jack. I really appreciate it. And of course, as always, I'd like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, Stitcher, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or would like to learn about any of the litigation insurance or funding solutions that Certum Group provides, including class action settlement insurance, which effectively transfers all of the financial risk and claims-made settlements away from the defending business to a third-party carrier and helps them exit litigation efficiently with absolute cost certainty, please reach out to me. Our website is www.certumgroup.com, and my email address is kevins@certumgroup.com. Thank you all for listening.